Okay, so guys, now that we've been through the steps of FIRAC and what the acronym stands for, we can now do an example to see whether we'd be able to figure this out if we were given a judgment. So there are a few examples in your textbook if you would like to become a bit familiar with the process, but I've also selected one that I'm going to walk through with you so that we're all on the same page. And just want to share my screen for you. All right, okay, so we are going to have a look at the case of Mahlangu versus S, which is on page 236 of our textbook. It's also going to be part of the slides here, so don't stress if you don't have your textbook. We're going to start with step 1 of our FIRAC, which is the facts. So we can see just from the title of the case here, it's Mahlangu versus S. What does that tell us? Immediately we can see that there's an S here that stands for state, which means that it is a criminal matter. So we already know just from looking at this little thing that we are going to be having a look at a criminal judgment. Okay. Okay. The S is also not listed first. So remember, the person that's listed first is the person that is coming to court, that is seeking some sort of an order. So in this case, we know that it's Mr. Mahlangu that is approaching the court, and S, the state, is the one that needs to answer. Okay. So if we had to have a head note on this one, which we don't, we just have our case summary. But if we had to have a head note, this is what it would look like. Okay, so we can see that we have an applicant, oopsie, we have an applicant, and we can see that we have a respondent. Okay, now what's a nice thing to remember as well is with a criminal matter, when we see that state is involved, not only is the Criminal Procedure Act or the Criminal Law Amendment Act normally applicable with a criminal matter, we also know that if we are having an appeal, okay, where the state is answering, if it is an appeal, there can only be really two things that we are appealing against. It can either be the conviction, whether I'm found guilty or not guilty, or it can be the sentence. So whether I received 5 years or 10 years, perhaps I think 5 years is too many or too little, you can bring an appeal to challenge what the sentence is, or you can appeal both. Okay, so you can appeal the fact about whether you found guilty or not guilty, and then you can appeal the fact about whether you got a fair sentence. It's always good to remember that, because when you see an S case, you can try and identify immediately off the bat when you summarize and you skim through your case, whether it is a matter where we are appealing or where the applicant or the appellant is appealing a sentence or appealing a conviction. Why is that important? Because that will be your legal issue. That will be the question that the court needs to answer. A, whether the person should have been found guilty or not guilty, or B, whether the sentence that the person got was fair. Okay, so remember, we need to complete our facts a bit more. So if we have a look at page 237 in our textbook, right, from the head note, we can also see that we are in the High Court, we are in Bloemfontein, we have an applicant, we can see that the state is the respondent. Okay. So if we had to read through this case quickly, we can list those facts, the who and the where, from our head notes immediately. Okay, sorry about that, guys. Right, so if I put the judgment on the screen for you, just to make sure that everybody can see what's happening here. Okay, so we need to identify some more facts. We now know who our applicant is. We know who the respondent is. We need to know a little bit more about this case. So what else is of interest here? Okay, the person was convicted on a charge of robbery. He was sentenced to 10 years imprisonment. We don't really need to know what time and where he robbed the store and all the rest of it, as long as we know that he was convicted for robbery, okay? And now we can see that the issue to be determined by this court is whether the 10-year imprisonment is fair. Okay, so we can add a little bit more then to our facts from this little introduction here. And we can answer or identify the legal issue immediately as well, because we can see that the issue, this is an appeal against sentence only. So the sole issue to be determined by this court is whether the 10-year imprisonment was unreasonably excessive. So once again, we've won the jackpot because it's telling us straight off the bat what the issue is. So we've got our facts down, we've got our legal issue down. Now we need to identify what the rule of law was in this case. So let's have a look and see. Okay, here we can see there's some case law, Cabido, S versus Malgas, S versus Vilakazi. Okay, so remember that case law, previous cases, can also be rule of law, because sometimes in a previous case they decide that from here on out, every case that is where someone is applying for a death penalty is no longer constitutional. So from here on out, every case that was seeking the death penalty can't be heard, okay, for example. So sometimes in cases, they actually make decisions and they make law through case law. So we can also list this S versus Malgas, S versus Cabido, S versus Vilakazi. We can list those cases as rules of law. We just need to remember, if we are listing cases as rules, we need to make sure that our full description of the case is here. Okay, so 2009, 1, SACR 552 at 574, that entire description needs to be under the rule of law. Okay, it's one long thing. You can't just say S versus Vilakazi, you will not get a mark. Okay, so we can list those as rules of law. And then we can see here the Criminal Law Amendment Act is what they've looked at. Okay, so that will be our rule of law, Criminal Law Amendment Act. Once again, I gave you a hint. Where you see S is involved, you know it's a criminal matter. So majority of the time, the Criminal Law Amendment Act will be the rule of law that's applicable. Okay, but don't just write it down when you see S versus whatever, because sometimes it's not. I'm just giving you a hint to guide you. Okay, so now we have to complete our application. We've identified our rules, which are all of these different cases, and the Criminal Law Amendment Act. Now we need to apply these rules to our set of facts. So what the judge did, but remember, we're not thumb sucking out of the air. We're looking at how the judge applied the rules. So if we read here, we can see that the judge had a look at all of the relevant factors and the provisions of the Criminal Act. And when they looked at the factors such as the seriousness and prevalence of the offense, the interest of the community, when the judge looked at that, he realized that imposing the minimum sentence, he realized that the court actually struck a balance between the personal circumstances and arrived at an appropriate sentence. So the court also had a look here and saw that the sentence is appropriate. So we know that when the judge had a look at the rule of law and the factors that needed to be considered when coming to a judgment about whether a sentence is fair or not, the judge had a look at these factors and he decided, you know what, in the first court, they came to the right decision. When I look at the factors saying that this is a prevalent offense, this is a serious offense, jewelry stores are robbed all the time. We need to protect the people of this country. It is a fair sentence that we arrive at. That is what the judge did when he or she applied the rule of law to this particular set of facts. And what was the outcome? What was the conclusion when the judge arrived at the conclusion after applying those particular rules? The judge came to the conclusion that the appeal against the sentence is dismissed and the sentence of the appellant is confirmed. So what does that that tell us. That 1 to 2 lines is our conclusion. That is the final outcome of this case, is that the appeal is dismissed and the sentence is confirmed. So ultimately, that tells us the sentence was found to be fair and just in the circumstances. Okay, so just to go through our memo again, okay, from the rule of law, which is where everyone seems to get a bit stuck. Okay, my suggestion is when you are reading through a case, highlight the sections that talk about in S versus Vilakazi, or in this case versus that person, or in the Criminal Procedure Act. Wherever you see possible rules, highlight them, because then it is easy for you to identify from the main judgment when you put it in your summary. Okay, so here we've highlighted it, and we've highlighted our rule here, our act. So now we can just list those under the rule of law. Okay. And when we apply it, I've explained to you that when the factors that were considered were applied to this particular set of facts, to the set of facts that our accused in this case robbed a jewelry store, it was found that the sentence was appropriate. Once again, our conclusion, 1 to 2 sentences, short and sweet, what happened at the end of the case. All right, guys, so this is the end of our first FIRAC. I will be available, as I indicated, via email if you have any further questions or concerns. But for now, I suggest that you do some research, have a look at some judgments and some cases. It can only help you to identify what the applicable rules are and how to find important information in a case.